So under this particular topic, we are going to define what is a contract, define a contract. So you are going to define a contract. Also learn about the essentials or characteristics of a contract. Essentials of a contract. We also learn about the types of contracts that you can have. Types of contracts. So we'll also learn something about how a contract is actually formed. So the formation of a contract. Formation of a contract. How is a contract actually formed? How is a contract actually formed? How is a contract formed? Then there's something about terms and conditions in a contract. Terms and conditions. Terms and conditions in a contract. Terms and conditions in a contract. What do you mean by terms and conditions in a contract? Then vitiating factors or factors that are likely to affect a contract or formation of a contract. Vitiating elements or factors in a contract. Vitiating factors or elements in a contract or elements in a contract. Vitiating factors or elements in a contract. Then we'll basically wind up by looking at discharge of a contract or discharge. We look at discharge, then termination. So discharge of a contract, discharge of a contract. Then we will look at lastly, termination of a contract. Termination of a contract. Termination of a contract. So we are going to define, we understand what do we mean by a contract. Then we look at the essential or basically characteristics of a contract. So what are the essentials that must be present for it to be concluded that there was actually a contract? What are some of the types of contracts that we can actually be able to have, or classification of contracts? Formation of a contract. How is a contract formed? How is a contract formed? So we're going to see how it can be formed. What do you mean by terms and conditions in a contract? So what are those things that you'll be able to say they are actually terms in a contract? And what can you actually be able to say are actually conditions in a contract? What are vitiating factors? What are factors that are likely to affect a contract or basically terminate or lead to a contract coming to an end? How can it be concluded that a contract has come to an end? So that's what we mean by discharge. Discharge is simply what can you be able to see in a contract for you to be able to conclude this particular contract has actually basically been discharged or fulfilled, or it has come to an end. Termination of a contract. How do you terminate a contract? Termination of a contract. How do you terminate a contract? So what do we mean by a contract? A contract is simply an agreement between parties. And basically, in this case, this particular definition has basically to be tied to the elements or the essentials. So if those essentials are actually present, it simply means that then it can be concluded that there was actually a contract. So first of all, we are saying a contract is simply an agreement between parties whereby they have obligations to be able to fulfill among them. So the best example you can actually be able to give, there's a contract between me as your teacher and you as a student. So you as a student, you have a particular obligation to be able to fulfill. In this case, you are supposed to pay the school fees. And on the other end, me as the teacher, I'm supposed basically to ensure I've provided tuition services to you as you prepare for your exam. So you can see that each of us are actually bound. Each of us are actually bound. You are actually basically bound to pay this fee. And me on the other end, I'm actually bound to be able to provide the tuition. So what do you mean by a contract? It is simply just an agreement of promises, which is legally binding or can actually be enforced under the law. So it's an agreement of promises, agreement of promises, agreement of promises. For example, this teaching is just a promise I've given to you. So you never know whether I'll fulfill or not. So you'll be able to see, for example, if I fail to fulfill, what can you do as a student? So that particular option whereby I've given you an option basically to pay, let's say, for example, maybe in installments. So it is just hopeful that you'll basically maybe be able to pay the remaining installments. So it is just an agreement of promises, which is legally binding and enforceable by law. It is legally binding and enforceable by law. So the most key thing there, it is an agreement. It is actually an agreement that has been entered into. And of course, this particular party is entering into this particular agreement. They are just giving promises. So these promises are actually legally binding and can actually be enforced under the law. So it is an agreement of promises, which is legally binding, agreement of promises, which is legally binding, and enforceable under the law. You can enforce it under the law, enforceable under the law. What do you mean by being enforceable under the law? We simply mean that if I fail to provide a tuition, then you can undertake certain steps, you as a student, under the law. If you fail to pay this particular tuition, you basically promised, I can be able to undertake certain actions. So I can be able to bring you before the courts, or I can hold you responsible under the law. So that is what we mean by a contract. That's what we mean by a contract. So what are the essentials that must be present? What are the essentials that must be present for it to be concluded that is actually basically a contract between me as a teacher and you as a student? So what are the essentials that must be present in this agreement for it to be concluded to be really, it is actually now a contract? Number one essential that is actually very key, there must be an offer and an acceptance. So there must be something I actually offered you as a student, and at the other end, you basically accepted. So maybe you just saw me online teaching, then I basically gave you an offer so that you can be able to either choose to join me as RCM or basically choose another place. So you actually ended up actually accepting, maybe by filling out the student registration form, you are registered as a student. So under any kind of agreement, for it to be concluded as being a contract, there must be what we call an offer and an acceptance. An offer and an acceptance. So number one, essential under contracts is what we call an offer and an acceptance. An offer and an acceptance. An offer and acceptance. So that is essential, number one. So the key thing to note about this offer you are talking about, this particular offer must be lawful, a lawful offer. It must be a lawful offer. And the other end, the acceptance must actually also be a lawful acceptance. So it must be something that is actually basically accepted under the law. So it shouldn't be that, in this case, I'm offering to sell you drugs, and these drugs have actually been prohibited under the law. It wouldn't lead to any form of contract between us. So in such a case, even if you fail to pay me, you can't go to the court. I can't go to the court to basically bring an action whereby I want you to fulfill your obligation under this particular contract whereby you fail to pay the money. So this offer must actually be a lawful offer, something that is actually allowed under the law. Provision of tuition or education tuition, in this case, it is a lawful offer. And you, of course, at the other end, when you give the monetary amount or give the money, it is a lawful acceptance. So it must actually basically be a lawful offer, and there must be a lawful acceptance. So that is essential, number one. Then the other thing that is actually very important, so there must be what we call a lawful consideration. So there must be what we call a lawful consideration, lawful consideration. So under any contract, there is what we call a consideration. So there is something, the price, what we mean by the consideration, it is the price the other party is paying under the contract. It is the price that you're actually paying. So under any form of contract, there must be a consideration. So you are paying me the money. So that is the consideration in this case. And on the other hand, I'm providing the tuition. So there's something I'm giving you as you give me something else. So there is always what we call a consideration under any contracts. Under any contract. For therefore, to be concluded that it is actually a contract, there must be a consideration. If it is an employment contract, you basically provide employee services to the employer, while at the other end, the consideration is actually basically to give the salary. So there must be something I'm giving as one of the parties, while also at the other end, the other party, there is something that is actually giving as the price. So what we mean by consideration is simply the price each and every party is paying under that particular agreement. So in any form of contract, whether it is a business contract, a business deal, or any kind of contract, for it to be concluded as being a contract, really it is a contract. One of the key essentials that must be present, it is that there must be a price. There must be a price the other party is actually suffering or actually paying. So that is what we mean by the consideration. It is the price that is paid by each and every party under the agreement, under this particular contract. So another thing that is actually very important is that there must be what we call the capacity to contract, the ability to contract, capacity to contract. For example, in this case, we'll just realize that, for example, those people have not actually attained the age of majority. So they are limited. So they are limited to be able to enter into certain contracts. So that's why, for example, if you are to, for example, acquire property in terms of, let's say, for example, land. So they'll ask you to provide your identity card or a copy of your identity card as the buyer of the land. So it simply means that the person who has not attained the age of 18 years, he's not actually able to enter into certain agreements. So there must be the ability or the capacity for each and every party under the agreement to be able to contract. So if they don't have the ability or capability, it will be concluded that this particular kind of a contract is not actually a valid contract. It is not actually a valid contract. Another thing that is important, there must be what we call free consent. So there's no way you'll basically force a person to enter into a contract. It must actually be through what we call free consent. So I can't force you basically to join my class. You'll basically choose. So maybe you'll be given options. Either choose this particular teacher or choose this other teacher. So there's no way I can be able to coerce you or basically force you to enter into a contract. So any form of agreement or any form of contract, it is important that for it to be a valid contract, there must not be any form of coercion or what we call undue influence. Because sometimes you might find that a particular person or a particular party has control or influence over another party. So therefore, in this case, he can use that influence to force the party to enter into a certain agreement or contract. So that kind of a contract will basically be seen as not being valid. It will likely be an invalid contract. Invalid contract. So any form of contract, for it to be valid, it must be concluded that it was actually entered into through what we call free consent. No party was coerced or actually forced, or maybe through undue influence, forced to enter into such kind of an agreement. So free consent is actually one of the essentials under a valid contract. Another essential is what we call, there must be the possibility to perform, possibility of performance, possibility of performance. Possibility of performance is like me telling you that I'll be able to take you through the whole syllabus for law, governance, and ethics within a period of maybe 2 weeks. So that is actually very impossible. So there's no possibility of performance. So such kind of a contract won't actually be valid because there's no way you can be able to cover this particular syllabus, which is actually very long within that particular period. So the other key essential or characteristic that must be present for it to be concluded as being a valid contract, there must be what we call possibility of performance. Possibility of performance. So if there's some element of this particular agreement not being able to be fulfilled or performed, then it won't lead to any form of contract, or the contract won't actually be a valid contract. So the other thing is that there must be what we call a lawful objects. A lawful objects. A lawful object. There must be a lawful object. So maybe that object that is forming the subject of the contract or agreement must be something that is actually lawful. It is not actually illegal. So for example, if it is a house, it is a house that is bringing you parties together to enter into an agreement. So one of the parties is actually a seller under the contract. The other one is actually a buyer under the contract. And the subject matter of them entering into a contract or an agreement is actually the house. So that object that is being negotiated for under the contract, is it a valid object? So it must be something that is actually lawful. So as we mentioned, for example, if it is maybe drugs, so drug trafficking is actually unlawful. So in such a case, the object in this case, it is not lawful. So it must be something that is actually allowed. It is not actually illegal under the law. So there must be what we call a lawful object. So what do you mean by a lawful object? It is the subject matter that is basically leading to the formation of the agreement or formation of the contract. So these are some of the key essential elements that must be present for it to be concluded that there is actually a valid contract. So sometimes they could ask you, what are the essentials of a valid contract? So there must be something we call an offer and an acceptance. So there must be a lawful consideration. As consideration we've said, it is the price that each and every party will pay under that particular agreement or contract. There must be the capacity or capability to be able to contract. So people of unsound mind, or a drunken person, or maybe a person who has not attained the age of majority, in certain aspects, they're actually they have the incapability. They're not actually capable to enter into certain contracts. So there must be the ability of the parties to be able to contract. There must be the ability of the parties to be able to contract. So there is a Harji Ahmed. You can mute yourself. Harji Ahmed. So these are the key essentials that must be present for it to be concluded that there was actually what we call a valid contract, that there was actually what we call a valid contract. So we can look at the classification of contracts. Classification of contracts. So how do you classify contracts? How do you classify contracts? Classification of contracts. So number one, we can have what we call an express and implied contract. So express and implied contract. Express and implied contract. So what do you mean by an express contract? An express contract, it is simply a kind of a contract or an agreement whereby the parties expressly agree on the terms. So they expressly agree on the terms. So the terms in this case are not actually implied or actually imposed on them. So it simply means that they can be able to agree, the terms, or they can be able to agree what will be the obligations of each and every party under the agreement or contract. For example, in this case, me and you as a student will be able to agree as to how much you'll be able to pay us the fee. So there is no set standard anywhere, for example, under the law that the fee you're supposed to pay for this particular class must be this one. So it just depends with how me as a teacher and you as a student, we actually agree. So we actually expressly come up with our own terms or obligations under the agreement. So in this case, what we mean by an express contract, it is where the parties under the contract, for example, the teacher and the students, actually agree on what are the terms or obligations of each and every party under the agreement or contract. So what we mean by implied, by an implied contract, it is simply a contract whereby the parties will be able to conduct themselves according to the requirements of already set terms or implied terms. For example, there is a law that is regulating that such kind of agreements. So you can't go away or basically run away from this particular set laws that are supposed to be followed. For example, if it is the government has basically passed a law, they have agreed that for each and every high school, that the school fees must not actually go beyond 50,000. So there's no way basically the school and the teacher will, the school, for example, in this case, the teachers will be able to charge a fee that is actually more than 50,000 for the students coming to the school, because that particular term in the agreement, that particular obligation in the agreement has already been implied or set under the law. So there's nothing you can be able to do about it. It's basically standardized for each and every such kind of an agreement, that this fee must not actually be able to go, must not actually go beyond 50,000. So there's no way basically you can be able to come up with your own terms as the parties under the agreement. So the standards, or basically the standards in terms of the terms, have already been set by the law in place. So in short, what we mean by express and implied contract, an express contract is a kind of a contract whereby the parties are actually able to agree on the terms by themselves, agree on the obligations or the terms under their relationship under the contract by themselves. So they come up with the terms. But of course, for implied, the terms are already set. So they are already standardized, for example, by a law in place. So you can't actually basically maybe try to twist them or come up with a new kind of terms. So you basically have to follow these particular terms that are actually already in place. Then unilateral and bilateral contracts. Unilateral and bilateral contracts is the other kinds of contracts that we can be able to have a look. So what do you mean by uni? It is one. What do you mean by bi? It is actually one. So a unilateral contract, it is a very rare form of a contract. It is whereby we only have one of the parties actually being obligated. So it is a kind of a contract whereby only one of the parties is actually bound. Only one of the parties is actually bound. But for bilateral contracts is whereby you have two parties, such that each and every party is actually bound under his or her obligations. So for unilateral, because you are saying in any form of a contract or normal contract, the parties are usually two. So we have, like, let's say, for example, the offerer and the offeree. Me as the teacher, I'm the offerer, you are the offeree, the one who's going to accept. But what we mean by unilateral in this case, it is a kind of a contract whereby only one of the parties is actually obligated. So the best example we can actually be able to give is, for example, if the government comes out and basically puts out a notice, or basically puts out an advertisement that they are looking for a particular criminal or certain criminal. So in this case, they say they put a reward, let's say, for example, of 20,000 or 50,000 for any person who will be able to identify where this particular criminal is actually located. So you can be able to see in this case, there is no any other party at the other end who is actually obligated, because any person from the public can be able to come out and basically bring in the information. So this particular obligation first of all, it is just on the government itself. So they are just hoping there'll be the other party from the other end who will come and basically bring the information about this particular criminal they are looking for. So you can see in this kind of a contract, it is only the government that is actually obligated to pay the 50,000. So there is no any other party at the other end. So someone can either bring the information or can basically fail to bring the information. It can be any member of the public. So they haven't chosen a specific party to be the offeree at the other end. So it is a unilateral contract. It is whereby a kind of a contract whereby only one of the parties or one of the parties is actually obligated or is actually basically supposed to maybe fulfill a certain term. So we have given an example whereby the government gives a reward for any person who is actually able to bring any information or require information maybe before them to identify maybe a search of a person like maybe a criminal. So that's what we mean by a unilateral contract. So it is only the government itself that is obligated to pay the reward. But of course, they are just speculating. They don't know who will be able to bring the information from the public. So anyone can come and bring the information, or anyone might actually fail to bring the information. The public is not actually even under obligation to bring the information. So they are not actually basically stating that it is a must, or the other party at the other end has an obligation to be able to fulfill. So if someone fails to bring that particular information, so it simply means that there is nothing the government can be able to do. They can't hold any other party at the other end responsible. So it is only, in this case, we are saying that only one of the parties under the agreement or contract is actually under obligation. So it is actually a very rare form of a contract. Most of the contracts are usually bilateral. They are usually bilateral. So we have two parties. So for a bilateral contract, it is simply whereby, or one in which both parties are actually bound. So we have seen under unilateral, only one of the parties is actually bound under the terms. For bilateral, both parties under the contract are actually bound under the set terms, are actually bound under the set terms. So that's what we mean by a unilateral and a bilateral contract. Then we have valid, void, or voidable contracts. Valid, void, or voidable contracts. So we can have valid, void, or voidable contracts. So a valid contract is one that has all the essential elements we've talked about. So there's an offer and an acceptance. It can be termed as being a valid contract. So it has all the elements we've talked about: offer and an acceptance, a lawful consideration, a lawful object, So the parties under the contract have the capacity to contract. So if those elements are actually present in a contract, it will be termed as being a valid contract. But of course, if there is any element that is actually missing in the contract, that particular contract will be seen as being void. It is the opposite of valid. It will be seen as being void contract. It is a void contract. So for voidable contracts, it is one in which one of the parties can actually be able to maybe walk away or basically just terminate that particular agreement or contract. So it is voidable. In case maybe if certain terms are not fulfilled, the contract has an option of actually being avoided by any of the parties. For example, in this case, if I miss to basically teach you like for the next 2 or 3 weeks without any valid reason, then you have the option as a student to be able to avoid or basically just terminate or walk away from the contract, or maybe ask for your tuition fee to be refunded. So it is a voidable contract. It is a contract that can actually basically be terminated or agree that it be avoided by any of the parties. So for a valid contract, we've said all the essential elements of our contract are present. And of course, you've seen the essential elements we've talked about: offer and an acceptance, lawful object, a lawful consideration, capacity or capability to be able to contract. Among those other ones, if they're actually present, then it can be seen as being a valid contract. If they are not actually present, or any one of them is not present, that kind of a contract will be seen as being a void contract. Voidable contract, it is one whereby one of the parties can actually be able to terminate it, of course, or actually decide to end up that particular contract, or just simply walk away from the contract. So that's what we mean by a valid, void, and voidable contracts. So we have what we call specialty and simple contracts. Specialty and simple contracts. Specialty and simple contracts. Specialty and simple contracts. So what is a specialty contract and what is actually a simple contract? So specialty contracts are the ones that basically have to be under a sale, or basically have to be stamped or be under a sale. So any contract that is supposed to be under a sale can actually be categorized or be seen as being a specialty contract. In ile contract lazima ikuwe stamped by maybe the signature, or basically maybe the stamp of the company, or it's supposed to have what we call a common sale. So for example, maybe a title deed must have maybe the common sale of the registrar of lands. So any kind of agreement that basically needs to be sealed, to be under a sale, will actually be seen as being a specialty contract. It will be termed as being a specialty contract. So there are those contracts that must actually basically be under a sale. So basically they are actually in writing, and of course they must be signed and actually sealed by the parties who are actually bound or supposed to be deliver that particular kind of an agreement or a contract. So any contract under a sale ni kama stamp. For example, hiyo receipt ya shule lazima istampiwe. So it is a contract under a sale. So it can be seen as being a specialty contract. So sometimes they use the stamp, or they use what we call, I think this one you know about it, common sale. So common sale. So common sale is the one that doesn't have an ink. So sometimes they just press and you'll be able to see it as appeared on the document. For example, your certificates. So they have the common sale of the Kenya National Examination Council. So you won't see the normal stamp there, but maybe if you view it maybe through light, you'll see something inside like a seal. So it is actually seen and known as a seal. So other places they use the stamp, other places they use what we call common seal. So common seal, any agreement or contract that is actually under a seal can actually be seen or basically be categorized as being a specialty contract. A simple contract, just from the word simple, it is actually basically just simple in nature. So it doesn't have a lot of terms or basically a lot of conditions. It can either be by word of mouth or basically be in writing. So a simple agreement may either be in writing or basically it can actually be done orally. And it's just simple as the way it is basically seen as being simple. Maybe it has not actually even been sealed, but of course it has just been signed by the parties. So it can simply be categorized as being a simple contract. It can be seen as being a simple contract. So you have another kind of a contract. It is known as a contract uberimae fidei. So you can say a contract uberimae fidei. A contract uberimae fidei. So uberimae fidei is not in English, it is in Latin. It means a good faith, or basically a contract of good faith. Uberimae, a contract uberimae fidei. So you can put in brackets, good faith. So the best example you can give is an insurance contract. So it is a kind of a contract whereby one of the parties has full knowledge of all the material facts that are supposed to basically lead to the formation of the contract. So he must actually be able to disclose these particular facts. So it is a kind of a contract whereby one of the parties has full knowledge of the material facts that are supposed to lead to the formation of the agreement or contract. So the best example you are giving is an insurance contract. So when you're basically entering into an insurance contract, for example, health insurance, they'll ask maybe on that particular form certain questions. which of course you as a person, or basically the person who wants to be insured, you are the only one who has the information. So no any other party has this particular information. For example, in this case, they could basically ask about your health history in your family. So maybe they ask, has maybe any of your family members suffered from any terminal disease? Maybe from your grandfather, maybe your father. So you can decide to lie or give information which is not actually factual, because maybe they are not actually able to verify or ascertain as to whether it is true or not. So what is supposed to happen in this case? You as the insured, you're supposed to act with what we call good faith. So at that particular moment, they can't be able to prove. So they're just relying on basically you as a party to be able to give the full knowledge of the material facts. So the information you give, basically they might presume it at that particular moment to be factual or basically true, because they might not actually be able to prove it at that moment. So it is actually known as a contract uberimai fidai. So it is a contract whereby one of the parties has full knowledge of the material facts that are supposed to basically lead to that particular contract. Then we have an executed and executory contract. Executed and executory contract. Executed and executory contracts. So just from the word executed, so this one has already been executed. It is actually in the past tense. So an executed contract is whereby each and every party or both parties have actually been able to complete the performance of their obligations under the agreement. So it is actually in the past already. It has already happened. They have already fulfilled. For example, in this case, this contract between me and you will be seen to have been executed by probably mid-April, because that is basically when you would have already done your exam. So it will actually be termed as being an executed contract. It is simply a contract whereby both parties under the agreement have completely performed their share of obligations. So they have completely performed their share of obligations. It will basically be termed as being an executed contract. Executory now is basically like the opposite of executed. This one, basically, the parties haven't yet fulfilled their obligations. So they'll be fulfilled at a future date. They'll be fulfilled at a future date. So I'll be able to teach you maybe the blocks at a future date. So that is basically a promise I've made that is supposed to happen at a future date. So that contract whereby both parties are yet basically to be able to fulfill their obligations or fulfill their agreement or contract will actually be termed as being an executory contract, as being an executory contract, an executory contract. And then we have contracts of record. Contracts of record, so it's another classification of contracts. You can say number 7, contracts of record. Contracts of record. Contracts of record. So the best example is basically judgments that are normally passed by judges. So judgments that are normally passed by the judges. So it is also basically one of the contracts is not actually basically a true contract. It can be termed as not being a true contract, because what we mean by these judgments passed by judges, there are certain rulings the court will actually make, or the judge will actually make, maybe against the defendant or the accused before the court. Maybe they say this particular defendant must limit his movement maybe for the next 3 weeks or maybe 1 month. He must not actually move out of his house. So that is something that this particular defendant or the accused must be able to fulfill. But of course, you can be able to see he's actually being forced. He has not accepted, because you've said under a contract, always there must be an offer and an acceptance. But in this case, the court has just basically made the ruling. So there is no actually acceptance at the other end. So it is not actually a true contract, but of course it can still be seen as being a contract. It is known as a contract of record. So they are basically formed by entry on the court records. So they are basically formed by entry on the court records. So they are known as contracts of record. So you're saying, for example, judgment that are actually passed by courts. So you as a party will just be forced to follow the judgment. So you have no any option, maybe either to rebuttal or do something. Maybe you can appeal at a higher court. But once they make the final decision or judgment, basically you'll actually be obligated. You will be obligated to ensure that you basically follow these particular requirements by the court. So those are some of the classifications of contracts. Those are some of the classifications of contracts. Those are some of the classifications of contracts.
Excuse me, sir. Excuse me.
Yes, you have a question.
Hello.
Yes, I can hear you.
Emphasize on point.
You're saying?
Emphasize on point number 5, please.
Point 5.
Before we proceed.
A contract uberimae fidei.
Yes.
Okay, maybe I can just repeat. So you're saying I emphasize on a contract uberimae fidei.
Yes, please.
So we are saying it is also known as a contract of utmost good faith. So you can say a contract of uberimae fidei or a contract of utmost good faith. So you say it is a kind of a contract whereby only one of the parties under the agreement of contracts has full knowledge of the facts or material facts that are supposed to basically lead to the formation of the contract. So the other party at the other end, he doesn't have the full knowledge. So the best example we've given of a contract to uberimae fidei is an insurance contract. So we've said, for example, in this case, the best example you're saying, for example, in that insurance contract, if it is a health insurance contract, you'll see on that particular form they have given you, they ask you, you basically answer certain questions. For example, the basic question you are giving as an example to be able to say that you are supposed to act with the utmost good faith, they ask, in your family, is there any person who has basically maybe suffered from a terminal disease in your family history? So probably there's no one who can be able to prove it from the insurance company, whether in your family you had a great-grandfather who had a terminal disease, they can't prove. But of course, they're just relying on you as the party who is supposed to be part of the contract to act with what we call anyusidanganye, utmost good faith. Utmost good faith. So they're not actually there to verify everything. So they're just basically relying on the facts you are giving so that it can lead to the formation of the contract. Because if you don't provide that information, you can't leave it blank. They'll ask you to fill it. If you don't provide that information, it won't lead to the formation of the contract. You must actually be able to indicate that in our family, there is no one who has basically suffered from any terminal disease. Because of course, this information is actually very important to basically try to gauge the risk. You know, insurance is actually basically a risk. So the insurance company can end up losing or basically gaining out of the agreement. So they are just speculating. So in this case, they must actually be able to look at the health history to be able to gauge as to maybe how much you are supposed to pay in terms of premiums. So in this case, that information you are giving, they expect you as an insurance company to act with utmost good faith. For them, at that particular moment, they are not actually able to verify this information. It will even be hard for them. So trying to basically go to the history of their clients, trying to find out if any of their maybe next of kin basically suffered from any terminal disease. So this case, you are saying one of the parties is basically supposed to act with utmost good faith and of course has knowledge of the facts, which are actually very important or essential to lead to the formation of the contract. So it will be termed as being a contract of utmost good faith. So the key thing there, one of the parties has the full knowledge of the facts that are supposed to lead to the formation of the contract. The insurance company, as one of the parties, has no information. You, as the insured, you have the information, which of course the other party can't be able to prove at that particular moment. But of course, it is important for this information to be given because it will form basically one of the material facts to lead to the formation of the contract. Such kind of a contract whereby one of the parties has the full knowledge of the facts that are supposed to lead to the formation of the contract, it is known as a contract of utmost good faith. Alternatively, in Latin, it is known as a contract uberimae fidei. Uberimae fidei. So that is a contract uberimae fidei. Hope you've gotten my point.
Yeah, sure. Well understood. Thank you.
Yes. So that is what we mean by a contract uberimae fidei. That is what we mean by a contract uberimae fidei. So those are some of the classifications of contracts. Those are some of the classifications of contracts. Those are some of the classifications of contracts. So I want us to look at something here. So we talked about the capacity to contract. So I want us to look at contractual capacity. Contractual capacity. Something briefly before we wind up the class. Contractual capacity. What do you mean by contractual capacity? It is the ability to contract. It is the ability to contract. So in this regard, we can be able to discuss something about minors. So minors are people who have not attained the age of 18 years. Other parties we can be able to discuss about are PUMs, or persons of unsound mind, persons of unsound mind, persons of unsound minds, and drunken persons. Do they have the capability to enter into a contract? Wewe unaweza enter into a contract na mlevi. Unaweza enter into a contract na mlevi. Will it be a valid contract? We are going to see that. Persons of unsound mind, a person whose thinking capacity is not proper. Can you enter into a contract na mwenda wazimu? Is it a valid contract? So that we are going to know today. So drunken persons. Also, we're going to look at a married woman. What is it? So you're supposed to know about a married woman. A married woman. Also, there's something about aliens or non-citizen. So do they have the capacity? Aliens or non-citizens? Aliens or non-citizens. Also, you're going to look at corporations. Corporations are companies. Do they have the capacity or capability? Do they have the capacity or capability? Corporations, we can also be able to look at maybe trade unions. Trade unions, Kina Francis Atoli. Trade unions, Kina Francis Atoli. Do they have the capacity to be able to contract? Kina Francis Atoli and Socion. Do they have the capability to contract? And then we can be able to look at also cooperative societies. Do they have the capacity or ability to be able to contract? Cooperative society. So these are some of the parties I want us to look at one by one and be able to see what is their contractual capacity, what is their contractual capability, because we are saying it is one of the essentials. It is one of the essentials under a valid contract. So you can look at different parties and see whether they can actually be able to contract. So maybe we can discuss something briefly about minors. What do you mean by a minor? A minor is simply a person who has not actually been able to attain the age of majority. So in this case, for example, in Kenya, we simply mean a person who has not attained the age of 18 years. So a person who has not attained the age of 18 years. So what are some of the contracts that will be binding for minors? So generally for them, they are not actually allowed to enter into contract, but certain contracts can be binding. So certain contracts can actually be binding. So what are the binding contracts for the case of minors? What are the binding contracts for the case of minors? So there are a few instances whereby a contract entered into. So generally, their contracts are actually basically invalid. They're not valid, or they're actually voidable or void. But of course, certain contracts that can be entered into by a minor and be presumed or basically be taken to be valid or binding contracts. So one of the contracts is what we call a contract for supply of necessaries. A contract, what is the contract that is binding? A contract for supply of necessaries. Supply of necessaries. So a contract for supply of necessaries. Also, another contract that is binding for the case of minors are beneficial contracts of service. So number 2, beneficial contracts of service. Beneficial contracts of service. Beneficial contracts of service. Beneficial contracts of service.